What you're about to watch is a probation violation hearing, a proceeding that happens after someone has already been sentenced for an original offense, when the court believes they've broken one of the conditions of that sentence. In this case, the underlying charge was operating a vehicle while impaired. The original sentence included fines, 12 months of probation, and 8 days on a court-supervised work program, a common alternative to jail that lets someone fulfill part of their sentence through supervised labor rather than incarceration. Two things are happening at once in this hearing, and it's worth separating them clearly. First, there's a disputed allegation. During a work program outing, the defendant allegedly took food he didn't pay for on 2 occasions. He disputes part of this, and his attorney has evidence, a credit card receipt, that may show he did pay for at least some of what he ate that day. Second, there's an admitted violation, a failure to report or complete a required step of probation, which the defense is prepared to plead guilty to outright. This distinction matters. Courts don't treat every violation the same way. An admitted, procedural violation is handled very differently from a disputed allegation that could turn into a theft finding. Watch for how the judge separates these two issues, adjourning one for more fact-finding while resolving the other on the spot. That's a real illustration of how probation violation hearings actually work, and it sets up everything that follows.
Would you say that for
Good morning. Counsel, I've got 2 files for Mr. Hart. One, no, that's not his. I got 1 file for Mr. Hart. November 12, 25, operating while impaired. Let's see, he was sentenced on May 14th. Fines and costs, 12 months probation, 8 days on the work program. He's here today because as part of our work program process, the supervisor took the crew to lunch, and on 2 different occasions, Mr. Hart helped himself to some food at the counter that he didn't pay for.
I talked to Mr. Hartz, and he actually showed me a credit card receipt for the day in question. I don't have the amount, and I was asking Mr. Lilly if we could adjourn so that I can get more facts as far as what the amount that we were disappointing was stolen on that day. If it lines up with the amount on his credit card statement on the same day for at the same restaurant, we would ask the probation to dismiss that one and allow him to complete his whole program.
Okay.
But we are prepared today to plead guilty to the violation of probation for the failure program or the failure to set up programs.
We'll do it all at once. All right. So hold on. I want you to be clear on something. My understanding is that you purchased some food at the restaurant, and you also took food at the restaurant that you didn't pay for. So I'll give you the adjournment, but just so you understand, today, if I find you responsible for stealing food, I'm going to give you 3 days in jail instead of the 3 remaining days on the work program. If you go through all this and it's determined that it's exactly what I say, you have a receipt for the food that you bought, but you don't have a receipt for the food that you stole, I'm putting you in for 90 days. So if you want to gamble that, you can gamble that, but I'm not asking questions right now. I'm not playing games with you. All right. I'm not asking questions right now. I'm just telling you where you're at. I think you're playing games with me. So if you want to play
that exchange is a clear example of judicial discretion in action, and it's worth unpacking. The judge laid out 2 very different outcomes tied to the same underlying dispute. Accept responsibility now for 3 days in jail, or contest it and risk a much steeper sentence, 90 days, if the court later finds the more serious version of events true. This is sometimes described informally as a trial penalty dynamic. Defendants are frequently offered a lighter consequence for accepting responsibility up front, with the implicit or explicit warning that contesting the matter and losing carries a heavier cost. Courts and defense attorneys debate this practice. Proponents say it rewards accountability and saves court resources. Critics argue it can pressure people into pleading guilty even when they have a legitimate factual dispute, simply because the downside risk is too large to gamble on. Here, the defendant chose to accept the 3 days rather than pursue the adjournment his attorney had just requested. That's a strategic decision made under real-time pressure, And it's exactly the kind of calculus defense attorneys have to walk clients through in probation violation hearings every day.
Want to play the game, you're talking, I'm not asking questions. If you want to play the game, understand that it has costs when you lose. So with that, if you want to talk to counsel, talk to counsel. If you want to just have a date to come back, I'll do that. And I'll have somebody from Blue Sky Restaurant here.
Please prepare to plead guilty to both, except the 3 days in jail.
Yes?
Three, two boys, the son, take care of full time.
Okay.
Their mother passed away.
I'm sorry to hear that.
Also, son, can't be able
How old are the kids?
Sons 4, the other 2, my daughter just turned 10, Joel 4.
Okay.
The daughter is 6.
Okay.
Taking them full time myself.
Okay.
Absolutely.
I'll give you some time. I'll give you a little time to make arrangements, but you're doing 3 days in jail. You don't have to start it today. No. It's not a money thing. Like I said, I'll give you some time to make some arrangements. And I would strongly suggest the 4-year-old's probably too young, but certainly the 10-year-old is old enough to get her some grief counseling. Get her some grief counseling. And if you talk to my probation department, they can probably give you some. Emily, did you get that one I just found out about the one in Northville? Hold on a minute.
I've seen when I passed on North Line Road, I think it's Beacon Baptist, they have a huge thing of grief sharing. They know that's the word that you usually use to counsel.
I'm not going to find it now. Just grief counseling. I'll just say that your daughter would benefit, but go ahead. I don't care. You owe me 3 days in jail. Like I said, I'm not going to tell you to start right now. I'll give you a little time. What's that? I want the jail done by the end of the month. And that's a gift. That's a huge gift. But I'm not going to wait. You got to tell me when you're going to report for jail.
Can you
Make some phone calls? Yeah.
find out?
Yeah. In the next half hour, I want you to come in here and say, I want to report for jail on such and such a day.
Like 2 of the days could be weekend days, Saturday and Sunday, or Thursday night.
I don't know. I don't know if anybody's doing that now.
And it is softer, so I'll have to contact Huron PD, so I don't know if they're gonna do 3.
Yeah. She can check, she can confirm that while he's talking to the boss. I don't care what days they are. If they'll accommodate him so he can do Saturday and Sunday, that's fine.
Next week, Wednesday, Thursday.
You sure?
Okay.
So that's the 24th. You'll report here at 9 o'clock in the morning. Got that, Mr. Rowley?
Yes.
All right. And once again, grief counseling.
Over 300.
That's, you still owe the money, whatever you got working out on that.
Okay, I think,
Mr. Nunley, you got anything ready? We're all set.
Step back from this hearing, and a few practical points about the justice system stand out. First, jail sentences aren't always immediate. Judges frequently have discretion over reporting dates, and here, the court explicitly delayed the start of the 3-day sentence to let the defendant arrange childcare, calling it a gift rather than something owed. Second, courts can factor in personal circumstances. In this case, a recent bereavement and sole custody of 3 young children. When deciding on scheduling and even suggesting outside resources like grief counseling without changing the underlying finding or sentence itself. Third, Financial obligations from the original case, fines and costs, remain separate and ongoing regardless of how the violation hearing resolves. None of this changes the outcome. The defendant still owes 3 days in jail for the violation. But it illustrates that sentencing in the US court system often involves more flexibility and case-by-case judgment than people expect, particularly at the scheduling and logistics level. Understanding these mechanics, the difference between disputed and admitted violations, the pressure created by sentencing risk, and the discretion judges hold even after a finding, is genuinely useful for anyone trying to understand how probation and violation hearings work in practice.